one of the things I wanted to ask you about is when you were a bankruptcy judge, you wrote, I think, probably the most comprehensive opinion on how we figure out what constitutes a municipality for purposes of eligibility for Chapter 9. And so can you talk a little bit about that case and what was at stake there?
Sure. Uh, the case was Las Vegas Monorail. And I don't know if any of you have ever been to the wonderful city of Las Vegas. I lived there for 14 years. And the monorail, you might go, what's a monorail? Is that a municipality? Well, the monorail did the type of financing that I just spoke about. That a monorail started as a transportation device between two of the hotels on the Las Vegas Strip, and someone got the bright idea to expand it as a transport alternative between the casinos, and they engineered this type of municipal finance that I talked about, where there were bonds issued that were tax free, and the construction cost somewhere, I believe, in the memory fades over time, because this case is about 14 years ago, was in the $360 million range in terms of expanding this monorail transport system to a series of 8 hotels. Now, the problem was that the monorail didn't connect to downtown and it didn't connect to the airport. And although the monorail was actually what insolvency lawyers would say a cash flow positive, it actually made, after all expenses, about $5 million a year. There was no way it could cover the debt service on the $360 million worth of bonds. It was its cash flow only covered about 10% of it, and so it was in a deep trouble. And so it wanted to file Chapter 11. Now, here's the problem. If you're a municipality, you can't file Chapter 11. Municipalities can only file Chapter 9. And Nevada, like Illinois, had not authorized its municipalities to file Chapter 9. So when the monorail, which was a corporation, filed for Chapter 11, almost immediately, within like a couple hours, the insurer of the bonds, again, another function of public finance, the insurer of the bonds filed a motion to dismiss, saying the monorail is not eligible to file Chapter 11 because it's a municipality. It has to file Chapter 9. Now, the reason the insurer did that is that the Nevada system was I think the technical world is horrible in terms of trying to figure out debts. And the insurer had a lot more leverage outside of bankruptcy than they would have in leverage. It was a complete, economic decision on their part. And so squarely before me was the issue of, was the monorail an instrumentality of the state? Because it clearly wasn't a political subdivision. It wasn't an agency. But the question was it an instrumentality of the state of Nevada? And there were lots of facts each way with respect to that. I don't know if you want to, Laura, develop kind of how you want me to go on this. I mean, my opinion was 30 pages, and I could talk 30 pages, but I don't think people here would appreciate that.
Yeah, so one of the questions I had for you in the monorail opinion and in focusing on the term instrumentality is you talk about, I think, how instrumentality appears in other areas of our federal law, right? Like US tax law might include entities as instrumentalities of a state, but that doesn't necessarily mean that US bankruptcy law would treat them as instrumentalities. And so I'm curious as to, if you could maybe talk a little bit about that and thinking about maybe the purpose of the legislation when you're trying to figure out what entities are included in a definition, or if we should have just one definition of instrumentality across all of our federal laws, or why do we have different versions of what an instrumentality is in tax law versus bankruptcy law?
It's probably because we're not very creative in our uses of words. But to address that, I mean, specifically, there are the same word is used in different statutes for example, the tax code that governs whether or not the bonds were tax-free uses the word instrumentality. And in fact, the Monorail had certified it was an instrumentality under tax law for purposes of getting the tax-free nature of its bonds, getting the cheap financing that it did. And instrumentality applies in other provisions. What I did in the Monorail case was to say, you can't, is that words don't have fixed meanings regardless of their context. And the context of municipality and instrumentality in the bankruptcy code is a different context than what tax law may do. And in fact, I wasn't breaking new ground there. There were plenty of decisions beforehand talking about if the same word appears in different statutes, because again, the instrumentality was in the tax code. The instrumentality I was dealing with was in the bankruptcy code. And there are lots of instances in commercial law in which the same word appears in different places and is treated differently. And I just said, or I had a discussion about, instrumentality in the bankruptcy code has to take into account, as I have bored everybody with before, the history of municipal bankruptcy and the function it is supposed to serve. In essence, getting tax-free bonds is different than getting bankruptcy relief under Chapter 9.
Thank you. So I want to get to a question that we got from the audience, but I just have one more that I'd like to ask, and then I'm happy to open up for Q&A as well. But one of the other things you note in the opinion is there's a difference between an entity engaged in a public purpose and an instrumentality carrying out a public function.
Right.
So how does this matter in U.S. bankruptcy law and for purposes of figuring out what type of entity we're dealing with?
Well, I mean, we see, for example, another way that municipalities or local entities address their financial needs is to outsource certain aspects. For example, one of the examples I used in the opinion was taxis are regulated by the city and by the government in terms of who can get a taxi driver license, what kind of cars they can have, what fares they charge. But we would never think of a taxi company as a municipality. It's serving the public in a way that buses serve the public, but in a different way. And so what I tried to do was to say there are certain entities, certain collections, if you will, that have the incidence or the qualities of a municipality. And I looked at things like, do they have a taxing power? Do they have eminent domain power? Do they have the types of things that we looked at a sovereign would have over it? And, private hospitals are regulated just as well as public hospitals are for different reasons. And so what I tried to do in that is to say, to look at the different levels of both regulation and control over the function that was doing so, and that then informed whether or not something was an instrumentality of the state. Because again, if the state wants to farm out, as we would say, certain functions, I mean, some functions it can't, and that's a function of municipal law. But to the extent it wants to engage with the private sector, you have to take a look at, well, what are they doing? I mean, the Monorail, for example, its board of governors was picked by the state, but its day-to-day operations were governed by just general law. The state did not create the Monorail. It was created by a private party. And took a look at, could the Monorail tax the citizens of Las Vegas? No, it could not. Could it condemn property to expand? No, it could not. So trying, again, to weigh a number of different factors that would lead you to believe that this is the type of sovereign, or this was a sovereign of a type that was intended to be within the cocoon, if you will, of Chapter 9.
Thank you. And I think you've actually just touched on one of the questions we received, which was, have any factors or criteria emerged from the case law around the definition of municipality in this context that appear to be dominant in making the determination?
It was, yes. I mean, like I said, can they tax? Do they have the power of eminent domain? How are the operations governed? For example, are they elected officials or are they appointed by elected officials? And so those tend to be important. And also, again, given the wide variety of types of aspects here, you also tend to look at how does the state view the entity that's been created? Is it like, the police department, right, which will operate separately, but certainly no one would say the police department is not kind of a municipality if it's separately incorporated. Or is it something subject to severe control as a police department? So, if a city hired a private security entity, would that entity be a municipality? And probably not, again, because if you're just hiring them for a particular function, and if that function isn't, critical and a core function of the city itself or the county or whatever, you've got it. So again, distressingly to the people who I had to give the opinion to, I didn't give a clear, sharp-edged answer. It's one of, I think, nuance, driven in fact by the fact that there's a multiplicity of ways in which a city can finance the needs of its citizens. And in one sense, you want them to do this, right? You want the city to offload as much of the burden as they can so that the general taxes stay low. You want to pay for what you get, but most of municipal finance that gets into Chapter 11 is all about these particular financial devices that are used to avoid tapping the general public revenue.